7:27 and a half. That's our time here on Sky 99.5 FM. And it's a busy morning on today's edition of the Breakfast Roundtable. I tell you, it's an embarrassment of riches, but you know what? It's all good because we're bringing you up to speed with everything that's happening, all the trending stories are making the news. And we've got another one of our professional facilitators on the line with us. We've got Mr. Martin George. He is, of course, a senior attorney and a member of the Police Service Commission. And we're putting the spotlight now on the September 7th elections. The Commonwealth Observer Team, they basically issued a report saying that the elections were conducted fairly and freely, that the EBC discharged its duties admirably, and they don't have a problem with how the elections were conducted. And Martin George, a question we want to put to you this morning is, will this finding of the Commonwealth Observer Group, will that have any impact at all on the elections petitions currently in the courts?
Well, good morning to you, Jessie May. Good morning to your panel. Good morning, Dr. Wayne. Good morning, Edison. Good morning to your listeners. And let me take the opportunity, first of all, Jessie, to wish all of Trinidad and Tobago a very Merry Christmas, a very happy and prosperous New Year, despite what may seem to be, so many stories we're hearing of, doom and gloom and, people, speaking about the economic circumstances. Yes. The point is, I think once we retain hope and faith and trust, and we recognize that we have to just basically work our way through this situation, I think it will turn out well in the end.
Martin George, as you were giving those blessings and good wishes, I felt the hug come through the phone line. So I'm sending it right back to you. Hug.
Thank you. Much appreciated.
Okay.
Now, in terms of the report of the Commonwealth Observer Team,
yes,
this report is basically a report on logistics, mechanics, and the actual nuts and bolts of the operation of the election machinery. It is not a legal opinion, and it is not something that is meant to be given a legal validation to any election issue. All it really does, it says that, look, in terms of what they were able to observe and in terms of your procedures, right, basically your physical arrangements for the elections, they are giving us a very great, excellent rating in terms of how we conducted ourselves, and which is consistent with the history of electoral, occasions in Trinidad and Tobago, right? So the thing is, we do have a very good, strong democratic tradition in Trinidad and Tobago. The issue, however, as it relates to these election challenges in court, they are looking at the constitutionality of the decision by the EBC in terms of the extending of the voting time in 39 constituencies, and they're looking at whether the EBC had the legal authority so to do, and therefore, in other words, they are questioning whether that was a valid extension. And they are saying that, look, they were disenfranchised, or, they were made to suffer as a result of this extension. The challenge that I think they will always face is not really from this report from the Commonwealth Observer Team. It's, as I've said from the get-go, their challenge will always be an evidential one. In other words, how do you prove what was the vote count in these 6 constituencies at 6 p.m.? In other words, if you are to raise this type of allegation, then you must show that you have somehow been disadvantaged. In other words, your claim really is that between 6 p.m. to 7 p.m., I lost the election. So in other words, first of all, were you ahead at 6 p.m.? Nobody in the world can prove that. No votes were counted at that time. Who voted more for one side or the other between 6 p.m. and 7 p.m.? Nobody in the world can prove that. There's no timestamp on your ballot paper. There's no observer in there with you to see who you are voting for, when you are voting, that type of thing. So these things will always remain their challenges. And of course, there's the next issue. Why are you only challenging it in 6 constituencies when the time was extended in 39 constituencies? In other words, are you cherry picking only the ones that suit you? Because in other words, if you are talking about the broad-based issue of the power, the fundamental power and constitutionality of the EBC's action, if it was wrong in 6 constituencies, then it has to be wrong in all 39. So why are you only choosing the ones that seem to be the ones that would favor you to say that you're challenging them? So I think it's been fraught with these difficulties from the get-go. And it appears to me that the judges of the Court of Appeal who ruled in the majority to allow the petitions to proceed, it appears that they may have taken the broader view to say that, look, while it may be possible on the technicalities raised by the Chief Justice to, shoot down the petition from the get-go, they may have felt that, look, let it be fully ventilated and dealt with one way or the other so that no one can say, well, I had a chance, but it's only on a technicality I lost. Because remember, from that decision of the Court of Appeal, there could be no appeal to the Privy Council in these circumstances. So therefore, I think that may have been the thinking that, look, let it be fully dealt with, because at the end of the day, I think these evidential hurdles will be the undoing of these election challenges once they, see the light of day.
But Mr. George, isn't there another charge by the UNC upon the autonomy of the EBC? Isn't there another challenge, I should say? One of the challenges is the autonomy of the EBC to extend that time from 6 to 7 o'clock?
Right.
Is that another argument?
That's the one that goes to the constitutionality.
Okay.
So they're saying that, look, under the Constitution, which gives the EBC that authority and power, they are saying that the EBC cannot, of its own volition, do that. Now, separate and apart from the esoteric, theoretical aspects of that argument, there's also the corollary, which would suggest that if it is that they were wrong to do it in 6, then they must have been wrong to do it in all 39. You see, so that is something that you cannot escape any way you cut it, slice it, or dice it. Because if it's constitutionally wrong, then you are looking at the fundamental root of their power. So that's where the nub of the issue is. So it's not just in the 6 that you have chosen. It would therefore be wrong in all 39. So it will be important, I think, for a court to eventually decide and determine, what would be the limits of the EBC's power. My own personal view, and I say this with the greatest of respect to all the parties, my own personal view is that I think the EBC does have that power when one looks at a combination of both the Constitution, the Representation of the People's Act, and you look at all the powers which are devolved to the Election and Boundaries Commission. Basically, it gives them that authority to manage the elections in such a way as to produce a fair result. Now, there are persons who have raised an issue as to, well, why extend it in Trinidad and not Tobago? So they're saying that, look, Tobago should have gotten an extra 2 hours. Now, there may be some practical aspects to that argument, just in that I think as a matter of prudence and as a course of, caution and, good administration, the EBC actually, I think, ought to have extended it in Tobago also. So in other words, because the election consists of 41 constituencies, if the extra time is given, it should have been given in all. But there's really been no challenge in relation to those 2 Tobago seats, save and except that there's been, I think, a constitutional motion that has been filed by someone, and they have alleged that. So we will have to see how that plays out. But in terms of the UNC's action, it relates really to the 6 constituencies in Trinidad that they have chosen. The 2 Tobago seats, those have been challenged by individuals who have claimed that they personally have been, disenfranchised by the fact that it was not extended in Tobago. So it's a slightly different issue, but also interesting, because in that regard, I am of the personal view that the EBC ought to have extended it in Tobago also, because this is a general election consisting of 41 constituencies, so therefore whatever you do should be consistent throughout.
Martin George, I want to go back to the point you made where you said, in your personal opinion, as a constitution expert, the EBC does have the power granted to it under the law, and I think one of the key things on trial here is exactly how much autonomy is too much autonomy, and exactly how much power is too much power. And what is the point of creating an independent body, giving it autonomy and power, if when things do not appear, when they exercise it in a way that may be advantageous to one but disadvantageous to the other? Not that they're picking sides, but they're exercising that power and authority. It's an outcome that the loser in the equation is unhappy with, so they want to cut off some of that power. They want to strap down some of that autonomy. Can we look at that for a bit?
The test that you really apply in those circumstances is the manner in which that power is exercised. It's the same way that, for instance, the office of the president in Trinidad and Tobago basically enjoys unfettered, wide-ranging power and discretion in terms of his official actions and duties, and there are, of course, the ouster clauses and immunities which, prevent his actions from being questioned and challenged. However, if it is that it can be shown that you have exercised your power in an arbitrary, capricious manner, or in a manner that is can be described as Wensbury unreasonableness, and that comes from the celebrated case of the chief of the Wensbury case, right? Associated Picture Houses versus Wensbury Corporation, right? So The thing is, if you can show that it falls within those categories, even though you have unfettered, constitutionally appointed power, the manner in which you exercise it must be consistent with the principles of fairness, natural justice, and basically good administration. Otherwise, that gives you a small window upon which you can challenge it. And I think that's where they are going with regard to the EBC in terms of how they exercise their wide-ranging power. So I don't think anyone is saying that, look, the clear and direct words of the legislation, which basically give the EBC that kind of unfettered power, that is wrong or that is open to challenge. What they would be saying is that, look, the manner in which they exercise that power, that is what they're challenging.
Mr. George, I want to just get some legal advice here and clarity, okay? Let's go back to the 6 marginals that we're arguing about, the cases about here. Can the UNC provide witnesses to argue the fact that, okay, if the margin of loss for the UNC in one of the constituents, I don't have the figures in front of me here, is, let's say, was 300. Can the UNC provide witnesses to argue the fact that, had I known of the extended time as a UNC member, and they can produce 700 witnesses to the fact that we would have voted for the UNC and we would have won the seat? Is that at all an argument that can be put forward by the defense, the legal team here, Mr. Sturgeon?
Well, one would imagine that somewhere along the line, that may be the thinking that, people are going to try to do that.
Okay.
But if you examine it from a logical and very, common sense perspective, you'd recognize the uselessness and futility of such an approach. Because how is a judge sitting on a matter such as this, presiding over it, to accept your word that if you were allowed to go down there in one of those 6 constituencies that you would have voted that way? No one knows what happens in a voting booth. You could be the most ardent UNC supporter or the most ardent PNM supporter, and you go in the voting booth. Either you vote against your party, you don't vote at all, you spoil your ballot vote. It may not be even intentional. You could spoil it accidentally. So how could any judge, if you understand me, because you see, this is a quantum leap of illogic. And I use that word deliberately because it's illogical to assume that because 700 people come forward now and say, look, if I had known, I would have voted for my party. Because what you are asking the court to then say is that, look, these are 700 votes they lost. That's where the trouble is. Okay. Because there's no way of proving that. Because those 700 people, they could swear on, every holy religious book. They could swear on anybody's grave that, yes, I would have voted. The point is, you didn't, and there's no way of knowing what you actually would have voted had you been there. So that's the difficulty and that's the trouble that we always face. And it's with good reason, I'll tell you why. Because remember, what happens in the voting booth is always private, confidential, and, it is really protected in the sense that you are allowed that freedom and privilege to vote whoever you want for, vote for whoever you want, and vote however you want, including the freedom to spoil your ballot. You recall that there was a group calling
the None of the Above campaign.
Deliberately spoil your ballot. I think former President of the Senate, Timothy Hammersmith was leading that charge, calling for people to deliberately spoil their ballots. So this is where, Vernon, this is where we will always have a challenge because no one will be able to see what would actually have been the results of these 700 people if they really had gone into the voting booth. And that's where the difficulty will always be. Because, you see, unless you can prove that, then you really have no case. Your case is a non-starter ab initio. And that always is the difficulty. So even if you get a theoretical ruling that, okay, yes, maybe the EBC ought to have exercised its powers in a different way, it will never change the actual result that we have here. And that's what I've been saying consistently from the start, and I do maintain that view throughout.
As you were describing the whole issue surrounding the voting booth, I couldn't help thinking there is almost a sinister of voyeurism taking place, wanting to know what goes on within the sanctity and the secrecy and privacy of the voting booth. And that element creeping into the case.
That's the point. We will never know. And nobody, no matter how much you swear now as to what you would have done, no judge can take that leap to say, yes, I will now count that as a vote for one side or the other. Because that's what you are really asking a court to do. And no court can do that. Okay. No court can do that. It makes it's a logical absurdity.
It's extremely discomforting, though, to the fact that, that very private, almost sacred space is being probed and prodded like this, apart from the autonomy of a body that we trust to be independent.
Well, the point is, Jesse, the thing is, I have no difficulty with opening these things up to scrutiny by the court in the sense that, look, let's test it from a legalistic point of view. But of course, that will in no way infringe upon the sanctity, as you say, of the actual process of what happens within that voting booth. And that very sanctity is what will be the undoing of this case in this matter, because nobody will know, and nobody will know what the vote count was at 6 p.m. So, in other words, you may have not been ahead, you may have been behind by the very number of persons you are claiming could have voted for you. So, in other words, in no circumstance it may be that you could have won. So it's really an esoteric theoretical argument, and we will see how it plays out in the court.
Can you take a couple calls from our listeners? They're anxious to join the conversation.
Okay, sure, Jesse.
Good morning. You're on the Breakfast Roundtable.
Yes. Good morning.
Yes. Yes.
Everyone.
Go ahead quickly, please.
Yes, I'll be quick. To refute Dr. Wayne's point, just as how the UNC could bring 700 people, the PNM could bring to show that they would, if they had known, they would have voted. Same way. Okay?
Yes.
And to actually support what the caller is saying, the current AG indicates that they have thousands of witnesses, so maybe they are also thinking of playing that game.
Mm-hmm.
But of course, it will have the same result. I think they're probably doing that to nullify whatever the PP government, their side, what they would have come with in terms of their witnesses. But at the end of the day, in terms of counting those as PNM votes, it's the same useless exercise. The judge will never count those as PNM votes. So I think they're just simply trying to match the numbers for numbers.
Let's squeeze in another call. Hello, good morning. Yes, hello, good morning. Could you listen to us on your phone, please?
A very good morning to you, Jesse.
Yes, good morning, Mr. Santa Cruz.
Good morning, sir.
Good morning, Mr. George. And
Yes.
seasoned greetings.
Yes, go
And
ahead.
seasoned greetings to you, Mr. George. Now, Mr. George, if the UNC were to lose the petition, would they have to pay legal costs? And to whom? Thank you.
If the UNC were to lose their petition, who would they have to pay legal costs? And would they have to pay legal costs at all?
Well, is that the question? Because I didn't hear him at all.
Yes, okay.
That would normally be a decision for the court, but depending on how the matter plays out, it may be argued that, look, this is of sufficiently great public interest that neither side should be punished with an order for costs. So it's too early to say how that aspect will be dealt with.
Well, we won't see very much traction in this particular case until about June next year, won't we? That's when the hearings come up again.
Yes, and the point is, Jesse, I could tell you, there's a great possibility that we may reach to another general election without there being a final resolution of this matter. So, it really, as I say, could end up just being yet an argument in sophistry.
Okay. Martin George, we want to thank you for giving us some of your time this morning and sending you Christmas hugs and kisses. Mwah, mwah. Just in case we don't talk to you again before Christmas Day.
Yes, sure, and all the best to all of you and that wonderful team at Sky 99. And I hope to have many more discussions like this in the new year with you guys.
All right. We've been speaking with the senior attorney at law and member of the Police Service Commission, Martin George, looking at the elections petitions. And I have the report that our colleagues at CNC3 would have prepared on this particular story with regard to the Commonwealth Observer Group. Let me see if I can get that to play for you right about now. It's basically in their report, they said that they found things were conducted properly.
3 months after the September 7th polls, a 6-member Commonwealth team has presented its findings about how this country elected a new government. The group arrived days before the election on the invitation of the EBC. The team released its findings in a 54-page document on its website today. It found that while there were some minor variations in some processes, these were not unusual in electoral processes and were not of such a gravity as to affect the smooth running or impact on the credibility of the election process. In its conclusions, the group, headed by Sir Paul Tavua of the Solomon Islands, said, The closing, counting and tabulation of results were in line with the prescribed procedures and conducted in a transparent manner by polling officials. It highlighted the exemplary role of the EBC, an institution it says enjoys a high degree of confidence amongst the electorate and stakeholders. In its report, it mentions the People's Partnership's challenge to the election results in 6 marginal constituencies. However, it says it felt that Trinidad and Tobago has capable domestic institutions and structures in place to address complaints, including legal challenges. The group said during its time, concerns were raised about voter padding. However, it did not observe any such instances, and it also felt the media's coverage was fairly balanced. One of its key recommendations is that priority be given to campaign finance reform.
And there you have it, that report there from Kimal George of CNC3, just bringing us up to speed with a few of the elements coming from that report generated by the Commonwealth Observer Group over the elections of September 7th, 2015.
Don't touch a button. We'll be right back with more on Sky